You guys are denying service because of my assistive devices.
That is correct.
It's been a while, so if you need to take a bit to go get refreshed on the issues arising out of Guilford County, North Carolina, please check the description for the link to the whole playlist. Once you're ready, come on back and we'll keep pushing through. Things were looking up in Guilford County Superior Court back in March of 2022 when Judge Class granted all of Mike's disability access accommodations, including funding the IRA visual interpretation service. Judge Class presided over a 2-day virtual suppression hearing, complete with evidence and witnesses. Mike's auxiliary aide, Mr. Simmons, was present in the courtroom and was able to help facilitate this process. Unfortunately, once court adjourned, things seems to stop. Mike was waiting on the judge's ruling and order from the suppression hearing. So, in April of 2022, Mike filed a motion to dismiss based on lack of speedy trial. On May 26th, Mike emailed Judge Class reminding him of the hearing and that Mike was still waiting for the order and to proceed with this case. He explained to the judge that he has, quote, also filed a motion to dismiss based on the state violating defendant's right to speedy trial. This case has been ongoing for over 2 years. The Superior Court obtained jurisdiction back in September 2021. Defendant has made numerous requests to the state to calendar the case and uphold defendant's right to speedy trial. End quote. The judge did not respond directly, but finally on July 15th, Mike got an email from the prosecuting attorney, James Capps. Capps sent a proposed order over to Mike to review before submitting it to Judge Class for finalization. Mike reviewed the document and found that almost nothing in the order was based in fact or supported by competent evidence presented in court. Mike made many notes and emailed them in a reply to Capps on the 18th in an attempt to correct the errors in the document. Capps responded on July 19th as follows. Good afternoon, Mr. Nelson. I received your reply. The proposed order, as well as your comments, thoughts, will be forwarded to Judge Class. Your matter was on this week's trial calendar, and I was advised by the individuals running court that you failed to appear for docket call yesterday. The Superior Court trial calendar for this week was published July 1st, 2022. An order for arrest was issued, however, I am unsure of its status at this point. Wait, what? Mike immediately responded and emailed the DACs, reminding them of his standing accommodations to be sent all correspondence digitally, that he cannot read physical mail, and the court's online calendar is not accessible. An email appears on the screen. You, the judge, the prosecutor's office, and the NCAOC have prior notice that due to my visual impairments, I cannot read printed materials. There are standing ADA accommodations / modifications in place to send me all communications / notices electronically to this email address. It's on the record I reside 15 hours away from Guilford County, and again, due to my disabilities and being pauper status, I cannot drive or afford the cost of travel to and from court. The court has also made the accommodations / modifications for my appearances to be via video link and to provide a visual interpreter. The trial court coordinator has also informed me that they would inform me of the scheduling of the case. The online court calendar is not accessible to me and I cannot read it. This case requires scheduling of video links and visual interpretation services, and it is unfathomable that the case would be calendared without these in place and without giving me prior notice of the dates, as I am pro se. Wendy and Lori, please process this email as an official ADA complaint of the threats and retaliation against me, a qualified person with disabilities. The arrest warrant is unnecessary and unfounded, and is simply a ploy of the state in attempts to discredit me and to use to support their arguments in my motion to dismiss based on lack of speedy trial. On August 1st, 2022, Wendy emailed Mike, informing him that Judge Craig recalled the order for arrest that was issued by Judge Gavin. So that's good. But in that same email, she goes on to claim that Mike has no standing accommodations. That's utterly ridiculous, as Mike outlined in his response. The full email appears on the screen, an excerpt of which is as follows. Thank you for working to get the arrest warrant removed. Will you send me an OCR copy of the warrant and the audio of the hearing in which said warrant was issued, please? As for the ADA accommodations modifications, they are standing and legally binding. The Americans with Disabilities Act doesn't require persons with disabilities to make requests for each subsequent visit to an establishment or for goods or services. The ADA does, however, require that denying requests must be in writing from a department head, and the entity must demonstrate how granting the request would be either an undue burden or would fundamentally alter the goods/services. Guilford County Court and staff hasn't done any of these things, and thus my accommodations modifications are still in effect and will remain in effect. Mike goes on to outline the standing accommodations that have already been granted and are currently in place. He also explained that the NC court calendar is not accessible to him with his assistive devices and requested that the court email all notices of scheduling, and to please ensure that the upcoming August 15th date is set up for WebEx hearing and that the IRA service is funded and available. Things continue to deteriorate. Wendy responds claiming that accommodations requests are up to each individual judge and that, quote, no judge has yet been assigned to conduct the hearing on August 15th. Once a judge has been assigned, we will submit your accommodation requests to the judge for decision. We expect a judge to be assigned by August 8th, end quote. The 8th? That's only 1 week before the scheduled court date. Again, this shows that these courts are not acting in a fact-based, unbiased fashion. If they were, then the DACs could objectively determine what accommodations needed to be made to ensure equal access for the person with a disability. You don't need a fancy robe to grant disability accommodations. On August 10th, a mere 5 days before court, Mike received an email from Wendy that included an order from a judge. Any guesses what judge it was? Come on, pause the video and toss your guess in the comment section. I'll give you a hint.
You shut down Google if you need to shut down Google.
Did you guess it? Ladies and gentlemen, I present Judge Stuart Albright, the same judge whose discriminative order Mike was in the process of appealing. The same judge that, even though he was named as one of the chief violators in a motion to dismiss based on lack of access and due process, chose to rule on the motion and deemed it without merit. Shocker. Oh, and the very same judge who threw a deaf man out of the courthouse because he didn't immediately surrender his ID when the judge asked him for his name in open court while presiding over a case that revolves around the defendant not providing ID as a passenger in a van. We won't spend too long on this order, but I do want to read a few sections and then review Mike's response. Albright stated, quote, defendant, due to his stated sight impairment and as far as the court can determine, has not made any requests of this court, but instead instructed the court about what his past accommodations have been in this case. End quote. Stated sight impairment? You mean blindness, Judge? Also, Mike has submitted many requests. They are in the case file. Albright continues, quote, the court conferred with appropriate officials at the administrative office of the courts to ensure that all reasonable accommodations are made before addressing defendant's accommodations for this session of court, which are set forth below. End quote. What does that even mean? How do you ensure that all reasonable accommodations are made before addressing the accommodations? How would you know if the accommodations you are offering are reasonable if you are not having a dialogue with the individual with a disability, unless you simply uphold the accommodations that Judge Class already granted? Albright, again, denied Mike access to the IRA Visual Interpretation Service, a service that Guilford County was actively funding at the time and was used in this same court back in March. Albright claimed that, quote, as a reasonable accommodation to this request, the court will locate and appoint a visual interpreter in person to assist defendant in this case. Also, as another reasonable accommodation, Mr. Nelson, as he requested, see below, will be allowed to use a personal assistant who can also describe to Mr. Nelson anything that takes place during the trial of this case. End quote. This statement alone shows the judge's fundamental lack of understanding what a visual interpretation service actually provides. He doesn't know because he is not engaging in the administrative dialogue process. Let me ask you this. Can you hear? If so, does that mean you are qualified to be a deaf interpreter? Nope. Can you speak? If so, does that qualify you to be a Spanish interpreter? Nope. As for Mike's personal assistant, he is there at Mike's pleasure and not to absolve the court of the responsibility of providing an interpreter. Mr. Simmons is not qualified, nor did Mike ask him to be his visual interpreter. Mike already tried to explain that to Albright in Rockingham County. Okay, last one for now. Point 13, white cane. Allowed as long as it is not used as a weapon or to intimidate any person. What? What is wrong with this man? It's a white cane. Some people feel intimidated by beards. Does that mean people aren't allowed to bring them into court? Why is Albright issuing directives about Mike's white cane? Mike filed a motion to recuse Albright. ADA requests are administrative issues, so while, yes, Albright needs to recuse himself or be recused for many reasons, the ADA issues themselves are supposed to be handled in the administrative realm. Albright prefers to hide in his magical cloak of judicial immunity. However, That cloak doesn't work in the administrative realm or when doing administrative things. So, Mike emailed the DACs to try to get immediate relief. An email appears on the screen. Greetings. I received notice yesterday, 10th August 2022, of Judge Albright's order. Albright has previously discriminated against me based on my disabilities in a case out of Rockingham County. That matter is pending in an appeal before the North Carolina Court of Appeals. Albright is again discriminating against me based on disability in this case in Guilford County. His order improperly and illegally denies my standing accommodations/modifications with the Superior Court in Guilford County. Guilford County Court demonstrated on March 2nd and 15th, 2022 that the accommodations, modifications can be granted without undue burden and without fundamentally altering the goods and services the court provides. Albright has no standing or legal grounds to unilaterally undo the progress the North Carolina courts have made in providing equal access to the courts. Albright's prejudice is palpable in his order, as he even included a threat while simultaneously attempting to grant the request of not making threats. In response, I filed a motion to have Albright recused from the case and a notice of appeal, appealing his unlawful order. But again, ADA matters are administrative issues and not judicial ones. So the proper and legal method to handle the accommodations, modifications, complaints, and remedies is administratively through the DACs. Please file and process this email as another ADA complaint. For your reference, Albright also issued a threat in his order by illegally denying my ADA accommodations, modifications, and ordering me to physically be in court on Monday, August 15th, 2022. That order is backed with the threat of contempt of court and/or a warrant for arrest. See 42 U.S.C. 12203 and 42 U.S.C. 12201. A person with disabilities can't be forced to accept a level of accommodation modification. I am hereby requesting ADA accommodations, modifications, in the form of immediate relief from the NCAOC via the DACs to remedy the situation and correct Albright's blatant violations of my human rights protected by at least the ADA, NC Constitution, and U.S. Constitution. The threats must be withdrawn, and the standing accommodations modifications that were present for court on March 2nd and 15, 2022 must be upheld and in place for court to proceed honorably and in accordance with the law and Constitution. I will not continue to be subjected to demeaning, dehumanizing, belittling, threats, coercion, or intimidation. I will not be forced to accept accommodations, modifications that are not reasonable and don't actually accommodate me in receiving access to the courts with my disabilities. Please acknowledge receipt of this email and send me the plan to rectify the situation in regards to my request for relief, ADA accommodations, modifications, along with a timeline for processing the complaint. Respectfully, Michael Nelson. So, Mike points out how the courts are constantly threatening him and that the threats, coercion, and intimidation must stop. Check out Wendy's reply. I'm telling you, these court personnel just can't help themselves. Good morning, Mr. Nelson. I have forwarded your complaint onto the NCAOC's Disability Access Coordinator in accordance with the grievance procedure. Also, in accordance with court procedures that apply in all cases, an order for arrest for failure to appear may issue if you are not present in court on Monday. She is essentially saying, if you don't accept the level of accommodation we are offering, we will issue a warrant for your arrest. That went back and forth a couple more times, and then nothing. No accommodations. On August 15th, 2022, Mike emailed the court letting them know that, quote, I am present and standing by for a WebEx link to be able to attend court today, end quote. Well, they did not grant Mike access to court on the 15th of August, 2022. The court was busy with another trial, so after Judge Albright took it upon himself to assign a standby counsel visual interpreter to Mike, he adjourned to the 18th. No accommodation issues were corrected or addressed. Albright did not allow Mike access to the proceedings, even though Mr. Simmons was present in court, waiting to connect with Mike. Later, Mike spoke on the phone with the man Albright assigned to be Mike's visual interpreter. Mike asked him if he had any experience being a visual interpreter. He did not. He agreed that simply possessing the ability to see does not qualify one to interpret the visual information. Court reconvened on the 18th, and Albright again did not allow Mike access, and instead issued a warrant for his arrest and a $15,000 bond amount. And that's where Guilford County sits, hell-bent on denying access to a blind veteran who has been acting in good faith this entire 4.5 years. Enough is enough. What is the justice interest in continuing to pursue these charges? Let us know your thoughts in the comments below. Thanks for watching. De oppresso liber. Some people feel intimidated by beards. Does that mean people aren't allowed to bring them into court?